The Retail Shop Leases Act of 1994, the Act, introduces certain requirements regarding the assignment of retail shop leases. Therefore, it is crucial for both the landlord and the tenant to understand their rights and obligations in the assignment process. Here are some of the things to consider when dealing with the lease assignment. Disclosure requirements. If you are a tenant, the assignor, you must give the prospective tenant, the assignee, a disclosure statement at least 7 days before asking the landlord for consent. If you are a prospective tenant, the assignee, prior to the landlord being asked to consent to the assignment, you must provide a disclosure statement to the assignor. You must also give the landlord a disclosure statement, a financial advice report, and a legal advice report, if you are not the major tenant, before entering into the assignment. If you are the landlord, you must provide the assignee with a draft lease and a disclosure statement at least 7 days before the assignment is entered into. Other things to note. Timing for the landlord's response. The landlord must respond to the assignor's renewal request within 30 days of receipt, notifying the assignor whether consent to assignment is granted or not. Assignment conditions. Subject to other conditions contained in the lease, the landlord cannot unreasonably withhold consent to the assignment. In addition, the Act prohibits the landlord from imposing new obligations on the assignee or withdrawing any existing rights currently enjoyed by the assignor. Release of future obligations. Provided that the parties have complied with their disclosure requirements adequately, the assignor will be released from ongoing obligations and liabilities under the lease from the assignment date. Costs. You should carefully check the lease clauses to see who needs to pay for the assignment costs, for example, legal and investigation costs. However, it is common practice that such costs of the assignment are met by the assignor and/or the assignee.